Good afternoon, and thank you everyone for attending today's webinar, Wage and Hour Laws and New 2020 Developments, presented by Robert Wilson and Chris Conti. Please be aware that there will be a question and answer portion today at the end of the webinar. To avoid frequent interruptions during the webinar, please type your questions in the question box located to the right of your screen. They will be answered in the order received during the question and answer portion. Additionally, an electronic version of this presentation will be emailed to all participants following completion of today's webinar, and a recorded version will be available on the website for members only. Again, we would like to thank you for attending, and I will now turn things over to Robert and Chris.
Good afternoon, everyone. My name is Robert Wilson. I'm a partner with Fisher & Phillips, a law firm that handles employment issues for employers, and I handle a lot of and represent a lot of clients in the healthcare industry, especially with regards to wage and hour issues. I'll let Chris Conti introduce himself.
Yeah, good morning, everyone. My name is Chris Conti. I'm a partner in the San Diego office of Fisher Phillips. As Rob said, we're a national employment, labor employment defense firm. We have 34 offices nationwide. And my specialty is, in particular, employment defense with unionized employers. I have defended numerous wage and hour cases against unionized employers, and then also general advice and counseling and single plaintiff employment defense.
And really appreciate and want to thank CAMGMA for providing this, because one of the biggest things that my clients run into is if they had only known about these wage and hour issues in advance, they could have fixed them before they end up in the litigation setting. So this is our opportunity to get out in front of these wage and hour issues, which have now become a specialty, and your attendance here today shows that you're already at the front of on the edge of learning and learning about these issues and being ready to deal with them before they become an issue, because now is a chance to fix a lot of the issues that you may or may not have. We have a lengthy PowerPoint. I understand we're not going to be able to cover it all today, but everyone will receive a copy of it. We want to provide you some substantive material so that you can review it later. If you do have any questions, we will be on the phone at the end of the call. People are free to drop off or to listen to our question and answer session. And if you do have any follow-up questions or just questions in general, feel free to call or email Chris or I. Our information is located on the PowerPoint that you will receive. Our roadmap today: wage and hour issues are attorneys and issues are very specialized nowadays. It's kind of like you have a general practitioner, doctor, but now you go to a specialist. It's literally become a specialty in the legal field as well. So I'm going to kind of give you an overview of wage and hour issues in California and Nevada. I could easily spend 8 hours on this topic. I often do 4-hour seminars, so I'm going to go quickly through these issues and then just to make you aware of them and use our limited time to provide you an overview of what's going on in the wage and hour universe. So we're going to start off with a background, generally of what's going on, talk about insurance, employee lawsuits, personal liability of supervisors, owners, officers, and perhaps most of the people on this phone call. Best practices to avoid or mitigate your wage and hour exposure, and some recent 2020 developments. So in general, you have two controlling laws. We have about 75% of our attendees from California and about 75 from California and 25% from Nevada. So I'm going to cover both issues. So one of the things that gets confusing for employers at times is which labor law applies. So you have the Federal Fair Labor Standards Act, or FLSA, or FISA, as some people will call it, which applies in Nevada. California has stricter laws with its labor code, wage orders, Supreme Court decisions, and enforcement. And what the FLSA is basically it's a floor. It's the federal standard saying this is the minimum amount of wage compliance you need to have. So example, you have a federal minimum wage, but you also have the states and various cities now going in and making their own adjustments, which they're allowed to do. So they can take the laws and make it more stricter and more employee friendly. And the states are starting to do that unilaterally due to the backup in Congress. So Nevada is controlled by the FLSA, whereas California is going to be mostly California Labor Code, because California is stricter above that floor on all of these issues. So most of the time in California, you're going to be dealing with specific California law, with the FLSA filling in for any gaps, and the FLSA trolling in Nevada with some local ordinances and statutes that will, again, raise the floor in Nevada. California has the strongest employee protections in the country when it comes to wage and hour issues. And just to kind of give everyone a background, when we say wage and hour issues, we're talking about basically employees' pay. You know, California's wage and hour laws are robust, and they cover all kinds of topics: hours worked, the minutes worked before, after a shift, pay periods, overtime, meal periods, rest breaks, which need to be paid for if they're late, short, or missed, wage statement or pay stub compliance, final pay. Everything is brought under this umbrella that we call wage and hour, including employee handbooks and such. Along those lines, we have novel issues too. So wage and hour compliance is important. It needs to become something that becomes to the forefront of your thinking. Often the Human Resources Department, if you have one, is one of the last departments that's added on to an employer. Often the individuals have not received specific wage and hour training. They're familiar with FMLA leave and various other things, but they're not aware of changing, almost daily changes in the law, at least in California, when it comes to wage and hour compliance and interpretations of the law. I represent, again, various medical clinics as our outside general counsel, and I also defend clinics and various medical entities with regards to employee claims. So a lot of it's not straightforward. What happens is a lot of employees or law school graduates now are graduating law school and starting off as wage and hour attorneys because of these huge paydays that you can see. If you Google wage and hour settlement or judgment in California and Nevada, you're going to see these multi-million-dollar settlements, and it's a ripe area for new attorneys and seasoned attorneys to get into. I've seen attorneys leave personal injury and just move over to wage and hour because you can make a lot of money over technical violations or gotchas. My current FQHC client is actually facing a new issue, which is something that everyone needs to now take into consideration for 2020. And it's going to be basically, it's a former employee who worked in customer service who filed a class action on behalf of all employees. So RNs, medical assistants, everybody that's hourly, even though this employee never worked with them, has no information about them, has no idea. They're going for everybody from IT and such. And in one of my cases, they're actually suing for, which we've always traditionally, you get your offer of employment conditioned on background check or drug test, which is mandated by federal law. I have a class action where they're suing for the time the employee took in traveling to the drug screening and actually being there and being actually handed new hire paperwork. So they made the employee an offer, gave him an employee handbook and various paperwork to bring to the new hire date and orientation. The employee read it and signed it, even if it was one page, and now is claiming time on behalf of thousands of employees for this gap period. So you want to make sure that your documentation is very clear now going forward. This is a client, unfortunately, that is stuck with an attorney that wants to try a new theory, saying that people should be paid for pre-employment drug screening when they haven't even started their job. They're not entering in payroll. And, when you get involved in a class action or representative action, whether it's in California or Nevada, you're paying money right out of the gate. It's one of those things where it's very surprising how expensive a class action or collective action could be raised by a single employee. So that's something you want to take a look at when you're reviewing your policies and practices. And at the end of this presentation, we're going to have some things for you to take away that you can bring back to your office and work on. And my goal is to get this information in front of you, have you thinking about it, and then hopefully to form a wage and hour team or committee to review your current policies and procedures and to make sure that everyone's working together. Because often I find situations where corporate legal attorneys file documents with the Secretary of State that lists the employer's name as one thing, and then the payroll wage statement has a different name of an employer completely, and there's just no communication. So you want to create a board or a synergy amongst your employees so that you know what's going on decision-wise when somebody makes a policy change or procedure or filing, and know how it's going to impact the rest of the organization. Again, we talked briefly about Nevada is covered, follows the FLSA, which again is the floor. It does have specific employee protections, such as higher minimum wage. The federal minimum wage has been capped at, I believe, $7.25 since the 90s. Nevada's got a two-tiered minimum wage process right now that's going up each year. Just went up. It's going to go up in July 1, 2020, increase annually. California has minimum wage broken down via cities, so you have to take a look even about how much time you have an employee that spends, they spend time in Oakland more than 4 hours. You have to pay the local city minimum wage rate versus what the rate is traditionally at your specific clinic or location. California's wage and hour law is comprised of the Labor Code, wage orders, the Division of Labor Standards Enforcement, which is the Labor Commissioner, court rulings, and the purpose of all these laws, in theory, is to make it a good and safe working place for employees. We all think of the traditional: you start your work, you work 3 or 4 hours, you take your lunch break at noon, you go home, you get your breaks. It all makes sense. A lot of these laws were logically put into place due to a long history of employees, having to stand on their feet for 8 hours and collapsing or not having access to bathrooms or various things. And then the plaintiff's bar has now taken it to the extreme where they take a look and basically do an audit. They're going to ask for the information on all of your employees. So I just want to briefly talk about insurance, because this is usually one of the big shocks that comes to an employer. So as an employer, you will have workers' comp insurance to cover if employees injured at work. You may have officers and directors insurance. You should have employment practices liability insurance that covers harassment, discrimination, anything along those lines. But what you're going to find out is that there's no wage and hour insurance. So as soon as you get a claim filed, you tender it to your broker or carrier. They're going to turn it around and say, sorry, look at the exclusion here or in the addendum that says we do not cover wage and hour cases. And there's a public policy behind that. Is the theory is if employers could be insured for that, they would just not pay their employees properly and then just wait till they get sued and then the insurance company would pay. In California, it's become such a high risk litigation area with such high payouts that insurance companies are actually pulling out of providing coverage, and it's very hard to get it. So I would recommend after this meeting today, you take a look at your current insurance policies and speak with your broker about what wage and hour insurance and exclusions you have, so you know. There are some policies I call Cadillac policies that will have a sublimit in it, which is basically they'll pay $50,000 to $150,000 of defense attorney fees. So they would pay, for example, my fees only at a discounted hourly rate. After you pay, $50,000, $100,000 deductible, So that provides some money there. So it's one of those things you want to take a look at your insurance policy to see if you have any sublimit of insurance or you have none at all. And that's what's scary. Out of all things that could break your company, it could be a former disgruntled employee that sues you over, late lunch breaks or missed, overtime, and next thing you know, you're talking hundreds of thousands of dollars right out of the gate just to defend yourself, and you have no insurance for it. And it's a shock to the CEO, it's a shock to any of your board of directors. So you want to be knowledgeable about this insurance issue and what insurance is being bought to see if you're person who's handling that, an accountant perhaps, are they getting a good policy? Or are they getting a Cadillac policy that actually has a sublimit, because it's something you want to definitely shop around for. Wage and hour litigation is expensive. It's plaintiffs' attorneys love it, again, because it's very easy to get into. They basically get to say, I challenge your compliance, and now I want all your time and payroll records for all of your employees. A lawsuit will be filed, and we will receive discovery, which is written questions or document productions. And one of the first things they always ask for is, give us all the name, address, telephone number. Sometimes they'll ask for email and personnel files of all of your hourly employees for the past 4 years in California. And you can imagine what that is, the impact of that. One, you don't want to turn this information over, but in California, there's a process that, because they are witnesses and you have access to the employees, that you will have to turn over names, addresses, and phone numbers. So that's why it's important that you get in front of this now and take a look at these wage and hour issues in your compliance, because they're going to ask for all the time and payroll records for all of your employees and then look for violations. They're going to go back 3 years from now and wonder why on May 1, 2018, a 30-minute meal period wasn't recorded. And if you don't have any documents behind that underlying to support why, you're facing potential exposure, especially if it's on a systematic basis. Judges in California will often ask, when it gets to like a class certification motion, so a case will start off as an individual case, and then they have a class certification motion where they want to represent all the employees, the customer service rep, all the way up through the RNs and IT people, all these non-related individuals, but except for the fact they work for your company. And then try to get their records and go through them, and they're just going to look for all these violations. And it's a tremendous amount of business interruption, expense on your part. You have your HR people that are going to be overloaded. You're going to have your legal trying to figure out this area of the law. Again, it's become a new specialty. So when you do work with your HR department, have them work with counsel, preferably focus or specialize in wage and hour, so they know what to look for, because it's very scary. You have a statute of limitations, depending whether or not you're in California, Nevada, that can go back 4 years from today. You could face potential liquidated damages, interest, attorney fees, costs, and all they need to do is basically prove one violation. They got you is going to be their argument, and then they come in and ask for attorney fees. At Los Angeles, it's common for attorneys to say their time and effort is worth $1,000 per hour. So they want you to pay their hourly attorney fee at $1,000 per hour, which is ridiculous. Some of the reasons why you should care, class actions and wage and hour have huge penalties which reach into the 7 or 8 figures. I mean, I deal with demands on a regular basis, $27 million, $3 million, $17 million, and nobody has this budgeted, nobody's aware of it. And we do these webinars, presentations to get in front of the issue, because my clients often ask me, they're like, I need you to go out there and do a white paper and tell people about these issues, because if I had known about it, we could have worked on it and fixed it. And all it takes is one employee. Everybody thinks that you need a large number of employees to file a lawsuit. In California, you just need one. And it's often, I've even seen class actions where the employees worked 1 week and then filed a wage and hour class action. Attorney fees can be substantial. Their plaintiff's attorneys could be in the $300,000 to $1 million range, and it's become kind of like a production industry. Like there's a law firm in California that has 150 wage and hour class actions going right now, and the medical field is a high target because of the turnover, and you have the high wage earners, and because it's they've worked through all the big companies and now they're down to mid-sized companies, and I'm sure there's people on this phone right now that are dealing with it. So they've turned it into a production line with that many cases. They'll have associates that literally do one thing, like just file complaints, another associate that just does depositions, another person that just does mediations and settlement negotiations. So I have a long list here of 17 things. I'm not going to read through them all, but you can take a look at them in your presentation. But these are some of the hot issues and compliance problems I run into. One is the insurance. You want to make sure that you take a look at your insurance to see what it covers and doesn't cover with wage and hour. Your Secretary of State corporate filings, do they match up with your pay stub? Most people don't even know. And the person that's filing the corporate documents is not updating the payroll wage statement to match. There's lawsuits over employer's name, missing a comma in the legal name. There's class actions where they will use a trade name or a trademark, but not actually put the legal entity that's referenced at the Secretary of State's website. So someone needs to go into that. And one of the things I learned is that everybody tends to think their payroll is perfect and great. I've not found a company that's ever been perfect. Often you have your CEO who's relying on your HR director and everybody in her HR or outside HR or their payroll company to handle all these issues. The reality is they haven't had the training, they don't have the experience, and the person that's actually processing payroll will say, I was never told to look for overtime or meal period or rest break issues, and they received no training, whereas the CEO, CFO thinks everything is being done. So you really want to get in front of this and start doing things. And among those is timekeeping systems, upgrade them. Basically, the California Supreme Court has said everything should be electronic now. You shouldn't be looking for time records in banker boxes and storage units off-site. Payroll companies are a big one. Whatever payroll company you're using, the salesperson will come in and say, we're going to do everything soup to nuts to cover you. We'll help you with the employee handbook and implementing your wage and hour compliance. But in the contracts you'll read, they actually write themselves out of any potential liability, and actually you have to indemnify them for if they get sued. Because basically, at the end of the day, they're just going to say, we just took the data you gave us and processed it. It's not our job to make sure wage and hour compliance was done or that the employee handbook was perfect, and you signed a contract in legal or accounting that HR is unaware of that states that. So take a look at your payroll company. Another common problem I run into is you'll change payroll companies, once or twice during a 4-year period, and as soon as you end that contract, they will go ahead and delete all your time and payroll records or wage statements because, again, the burden, they say, is on you to download and keep track of all the statements. So you want to make sure somebody's doing that versus relying on just going back to the payroll company, because the payroll company, at the end of the day, if you're lucky, might give you 1 year's worth of PDF files. And, under California law and Nevada law, it's your burden of proof to prove when these employees worked and to prove they were properly paid. So various other things on this list I'm happy to go over with more detail at the end. And here's another big surprise to everyone that I interact with when I first deal with it. Again, our firm I specifically handle preventative on the front end from employee handbooks all the way to the end litigation. So when I go through a client, it's like a trauma. My job is to mitigate and get them back into a position like a patient would in the ER so they can survive and move forward, but then at the same time, make sure they start off with a clean slate. So you want to do that as well by staying in front of it and think about this topic. California is also unique, and Nevada has the same situation, is that supervisors, owners, officers are personally liable for wage and hour issues. So, back in the old day, you would have company A that would just go bankrupt and they would start company B and say, hey, we're a new employer, and the other company has no assets or money. That was the end of it. So California changed the law, and Nevada has gone along with it to a certain extent as well, where they're saying there's personal liability now for supervisors that control work into breaks and situations, that type of thing. So there was various people that are shocked to find out. I go to work, I'm a supervisor, I just basically tell my employees to take lunch breaks. Next thing you know, I'm getting sued. Your name's on a class action lawsuit which interferes with your life and trying to get credit or refinance your house or anything along those lines. And then you find out at the end of the day that you're liable for $6 million along with an employer, which may go bankrupt, and next thing you know, you're sitting there personally liable for it. I've seen it happen, not with my clients, but there was a tow truck company that got sued and basically paid about $5 million to the California State Labor Commissioner. They then went into each individual's owner's house, put a lien on it, put a lien on their vehicles, froze their accounts receivable so they couldn't make payroll, and basically just tried to gather as much assets and money as possible. So it's important for supervisors. You can't just sit back and expect HR to be doing it with employee handbook and such. If you're a supervisor, you need to be active and moving forward with it. Employee handbooks are super important. It's your shield. Most people don't read them from page to page, but you want to make sure it's updated. If it's more than 18 months old at this point, it's outdated, whether you're in California or Nevada. The laws constantly change and court interpretations change. So you want to make sure your employee handbook is recent. You want to hand it out to your new hires, have them sign it, give it to your current employees, make it available. Say it's in the HR via email, or it's emailed to everybody, or put it on your internet so it's downloadable. Always say it's available, because you want to be able to modify it. I have various strategies I can discuss with you if you have questions about it, or you can speak with your counsel, but it is the first line of defense, which sets forth your wage and hour policies. I've read 100 plus page employee handbooks that have had no wage and hour policies in it, which is a certifiable issue on its own. They just didn't put any meal periods or rest breaks or pay things in there. And as much as the employee handbook was nice and long, it didn't cover the key critical legal things that needed to be included. So who must keep track of their time in California and Nevada? Basically all non-exempt hourly employees. And one of the hot topics for 2020 is misclassification. You'll have cases or situations where an employee will say they're misclassified. You have the hourly employees that want to be put on salary because of prestige. You have the employees who are on salary who get knocked down to hourly, and then they feel like it's a demotion. But in reality is the tests have changed. So all it takes is one employee to say they're misclassified. They file a class action, for example, and then they're going to request discovery. For example, one of my cases, they're asking for all the job descriptions of all the hourly employees, but they also want everybody who is considered exempt. So that includes pretty much everybody from the president on down, because they want to look at people which are wobblers, I call them, where sometimes they're doing hourly work and other times they're not. So you don't want to be in the situation. Again, your employee handbook and your policies are very, very critical. And your records. At the end of the day, it's really a game of data. The more data you have, if you have data on all your employees, if I could turn to you and say, produce 4 years of time and payroll records for Megan Walker, and you could do it very quickly in an electronic format, you're in a good shape. If I ask you that and you cannot do it, or you're missing a year, then you start having issues, because you always want to think of this as like you're being audited. And it could be either the state of California, the state of Nevada, it could be the federal Department of Labor comes in and does audits, or these lawsuits. So it's all about records, records, records. And one of the important things I want to say is try to coordinate your policies through a single entity, whether it's your HR person or your office manager, because one of the challenges I often see as well is that you'll have an excellent employee handbook that's been prepared by counsel. You'll have excellent worksite posts and such, but then you have an employee as a supervisor or a nurse manager that sends out an email saying, you know what, employees have been late to work, so I need you to show up 15 minutes early before you clock in. Well, that's a change in wage and hour policy, and then that email would make the company responsible for those 15 minutes, and HR has no idea this email went out. So you want to make it clear to your supervisors and officers and everybody that, you know, everything's got to go through a process where it's reviewed, approved, and you can't just send out these individual notices to employees. I also had an email from a nurse manager that said you can't leave the premises during breaks, and that's illegal in California, which my medical clinic clients are now having to deal with. That one specific clinic where we have a manager who said, did a clear violation of the law in writing and sent out an email to these employees. So don't let your supervisors, create their own policies or modify them without your input and your review. Comes to meetings and training. That's a big thing. You want to make sure you pay everybody for training and meetings. You want to, basically in both states, you got to pay each employee for every single minute. So don't try to create voluntary meetings, like, oh, if you show up to this, that, pay the employee, treat it as a mandatory meeting. Be sure to schedule meetings to coordinate with breaks, because often people will schedule a lunch meeting and provide lunch and that type of thing. That is not going to give the employee off-duty meal period and then just pushes you into violation. The better practice would be to give them an earlier lunch before the lunch. That way they've taken their timely 30-minute break, which in California has very specific timing requirements versus Nevada. You want to make sure you're keeping track of your schedules and work things. One of the things I'll ask for is your scheduling of specific employees, and nobody retains them. Again, they rely on the payroll company or HR, and often these records are not exist anymore. Some of the differences between California and Nevada, just briefly go over it. In overtime, both states, you're entitled to overtime over 40 hours in a week. In California, we have over 8 hours in a day also. So anybody who works over 8 hours in California is entitled to overtime. We also have in California the first 8 hours on the 7th continuous day of work. And then you have some various double time requirements. Again, you want to put these in writing in your employee handbook and not just work off a basic bare bones model, because you need to spend the time, effort, money to make sure everything is right on the front end to avoid these multi-million-dollar lawsuits and six-figure defense cases that you could have avoided if you spent the time and effort on the front end to make sure everything was current, updated, the employees are in compliance, and someone's enforcing it. Some of the things you cannot do, deny payment of overtime. Somebody works, I'll just work a few extra minutes to help you out, but not, on the clock. That would be a problem. Ask employees to waive overtime, giving an employee extra vacation or PTO in exchange of overtime. I know lots of budgets don't permit overtime, and supervisors are maybe ranked on how much time they have employees doing overtime. You want to make sure that they're not alternate time records to round down to avoid all time. It is critical that you have employees sign off on any changes to their hours. So if a supervisor changes a punch in or a punch out because somebody forgot to punch in or punch out or they're late, make sure the employee signs off on it, because otherwise you're going to have the company and the supervisor accused of alternate time to avoid overtime. I've actually seen this, believe it or not, supervisors who have an incentive to keep overtime down will offer to pay employees out of their pocket so not to record any overtime on payroll. Again, that would be illegal and against company policy, and that's why you want to have these things in a comprehensive employee handbook and written policy that's current and up to date. It's going to protect you, and in California, it's only a matter of time to get sued. One of the common trends in 2020 is now pay equity. Misconception is most employers believe they don't discriminate. They take everybody by individual basis, but you need to really do an analysis or audit of that. Take a look and go through each employee and what their work is and how their salary is being paid. You cannot base it on the prior salary. So if they were making $70,000 before and you just added $10,000, you're perpetuating or continuing the discrimination against females in theory. And at the same time, if you have a male counterpart in the same role or condition, even if they're at a different clinic or location, they need to be being paid the same salary for comparable work or hourly rate. Equal pay laws across the country, they've been hitting every large company and they're working their way down. There's going to be a wave of these, so it's time to get in front of it and work on it. You want to mitigate your exposure, and again, you have no insurance for this, so make sure that we start working with it. It's also a hot topic for the EEOC, which is the state enforcement agency. They're going around we have the Equal Pay Act, which is set forth here, but they've also considered a priority for enforcement. So the state is now, or the feds are now coming in or sending you a subpoena or a request for all of your documents, wage and hour documents for hundreds of employees, and then they're just going to do a comparison like a forensic accountant or CPA would do. So you want to make sure you have a defense to it, because at the end of the day, you defend wage and hour cases with documents and evidence. And if you don't have documents and evidence to prove that you did something, you're going to have a challenge. One of the problems is that if you do end up sitting in a deposition, for example, or you go to a labor commissioner hearing, they're going to turn to you and ask you as the company and you individually, what have you done to ensure wage and hour compliance? And falling back on saying, well, we have an employee handbook from 2015 is not going to be sufficient. You want to show you're proactive and that you're taking the steps that are required by law. You want to have a 2020 employee handbook. You want to have policies that are facially correct. You want to have compliance that's ongoing. You want to say, we do supervisor training. For example, I know law firms will do train the trainer training, so you could save money there. For a lot of my clients who are very cost conscious, they don't want to have, say, our firm come in and train each supervisor individually. So we'll train the supervisors so that they can go through and do the training, and then document that these supervisors went through this training. So that way you have documents and evidence to support that you're really taking this stuff seriously. I recommend, as a best practice, sending out a quarterly reminder about meal periods and rest breaks in both California and Nevada. It's a simple email just saying, hey, it's a reminder, on a quarterly basis. Here's what our policies are. Here's our procedures. If you're not able to take your breaks, let us know. It might be a staffing issue. It could be a supervisor issue. I recommend a standardized form in order to, as a best practice, in order to report issues with missed punches or breaks and such, because otherwise everybody just tells their supervisor orally or sends an email, and then that gets lost. The supervisor leaves and then their email account gets deleted. There's no record that the employee said anything or did anything. But if you have a standardized form that's sitting in your break room next to your worksite postings, or that's been emailed to everybody as an attachment saying, hey, if you have any issues, report them. And then you have HR is going to have a systematic way of looking at issues and making sure that payroll issues or wage and hour issues are corrected. So the more you can standardize your wage and hour practices and take out the potential for human error, the better. And just to kind of give you an example with the equal pay lawsuits, they're costly to defend, even if you're not doing anything wrong. Here's one company that paid $19.5 million settlement. Another one, $8.2 million. Internet company, $1.2 million, and that's just for 211 employees. $4 million plus another almost $2 million in fees for 300 employees. So we are talking break the bank. You're going to, have some serious explanation to do with your managers and the board of directors or your owner or supervisor when you're expected to be knowledgeable of these issues, but you're unaware of it. So that's why we're here today, to kind of give you an overview of these issues so you can learn more and become more engaged. Various required postings, for example, in California, I'll find this Wage Theft Prevention Act notice either not in the personnel file, or if it is, it's not signed, or it has the wrong legal entity on it. So it'll be like, here's the name of the legal name of the hiring employer will be XYZ Corporation, and then we go to the California Secretary of State, and it's, NBC is the legal employer. We have wage orders in California that are in 3 languages. I recommend that you post them in English and Spanish. I guarantee my experience has been 90% of employers I've gone to do not have the wage order posted, which is a mandatory wage and hour document. You can find it easily on the internet from the state, download it for free and post it or thumbtack it to the wall. It's going to be one of the other big shields. Everybody has the giant plastic poster with federal laws and everything else, and they think they have all the job posting requirements up there. The California wage order is actually a separate document, so it should be a whole separate plastic printout versus the giant one you're used to. If you don't have your wage order, something you want to get up immediately, feel free to reach out to me or Chris if you want to determine how to implement that or get that posted or where to find it. But it's one of the most important documents because, as you'll see, it covers pretty much all the big wage and hour areas right now that lawsuits are being filed over. So here's an example of a wage order. This one's number 2, relating to the personal service industry. There's about a dozen wage orders, so you got to figure out which one applies to you. Probably a lot of you, it's going to be wage order 4. There's even a manual from the state that helps you figure it out. But you go through, you'll see all these various categories. It sets forth minimum wages, report in time, license, records you have to keep, uniforms and equipment. Make sure you're providing all the equipment and uniforms to your employees. Don't ask your employees to be paying anything out of pocket. And then some of the big ones: meal periods, meal periods, and rest periods. So if you don't have a compliant policy right now, or you don't have an employee handbook, this wage order will at least give you a minimum document that you're required to post anyway that shows that you have a legal policy in place. And this is what your meal period and rest period policy should look like. If it doesn't have, if you don't have a policy that has meal periods and rest periods that mimic this or mirror it, then you need to definitely update it. And you got to start really making sure your employees take their breaks, if you actually do. Another area of hot topics of lawsuits right now, believe it or not, is seats. It's been a big wave in 2020, and what it involves is basically if you have an employee who's standing on their feet all day, such as a nurse or someone in the front office, or out in the real world, someone who's at Rite Aid or CVS or Bank of America, and they don't have a seat and they have to stand all day, there's a violation of the wage order. Here, it requires that you provide a seat to employees and have one available so they can sit down. And you're going to see going more forward, at least in California, when you go to Target and various other places, that they are going to have the registered people are going to be sitting down. And just to kind of give you an example of the recent settlements, CVS just paid $19.5 million for seats in California. Bank of America paid $15 million as a settlement. Walmart, we all know Walmart and the people standing at the register and such, just settled in California for $65 million over seats only. So everybody's getting hit with these seats. And then there's one of the interesting things, that just to show how much California regulates everything, look at the temperature section at the bottom. They actually regulate the temperature of the bathroom in your office while in use. And I know we're on mute right now, but I normally ask, what temperature do you think you have to keep your bathroom at? And the answer is right here, that the temperature of the bathroom needs to be 68 degrees when the toilet's being used by an employee, and I'm sure no one has ever checked the bathroom temperature where they work, but this goes to show how heavily regulated California is, and Nevada is pretty close. Nevada is more employer friendly, California very employee friendly. So, but these would still be good best practices. When you take a look at the PowerPoint later today, you'll see we have charts or graphs on when meal periods and rest breaks are owed. A rest period needs to be paid. It's considered on duty, and it's important to make sure that you notify or allow your employees to leave the premises. A lot of older employee handbooks will say you can do whatever you want in your meal period, but on your rest break, you have to remain on the premises. Take a look at your employee handbook. If you have that in there, you need to update it now, because the law changed, and that would be a violation that would be certifiable and possibly cost you millions of dollars. California employee meal period requirement, which is set forth here, you want to make sure they're full 30 minutes. You want to come up with a system to prevent employees from clocking back in at 28 minutes, 29 minutes. It's not a full 30 minutes. The court's going to look at it, whether it's 30 minutes, 29 minutes is a violation. So you want to work with your HR department and counsel on how to come up with a system to prevent employees from doing that. It's got to be uninterrupted. A lot of nurses, I find, take their work phones with them or pager so that they're on call, on lunch or on a break to make sure they're available in case they have questions about a patient or such. But that is illegal in California under Augusta's case. They have to leave their phone and pager and literally be allowed to go off into whatever land they want to do and do whatever they want and not be on call. Otherwise, you have to pay them for that time. We have a refresher here on meal periods. Often second meal periods are forgotten, so take a look at your employee handbook and policies. They'll talk about a first meal period, but they won't mention or have a policy for a second meal period in California, which is required after 10 hours. And that happens a lot, especially with individuals who are on an alternative work week or working 3 12-hour shifts or 10-hour shifts. You want to make sure that you're in compliance with that. Rest break law set forth here. The major fraction thereof language comes from a Brinker case. Again, I see a lot of policies where corporate offices outside of California or general counsel prepares an employee handbook, or it's done in-house based on a prior employee handbook that's been used for years and just modified, and then you're missing this major fraction thereof language. So please take the time to look at your policy to see if it has this language in it, and various other things to make sure that you have language stating that it's authorized and permitted, and if not, write in, again, it doesn't exist. If you don't have a record, a policy, it's hard to argue that you're in compliance when you don't have a policy about meal periods and rest breaks. And then when we look at your time records, no one's reviewing them. Just kind of give you an example, why is this such a big deal? A premium or penalty on your wage statements. One of the questions that's often asked is, what is your payroll code for meal period premiums or rest break premiums? And what they're asking is, what's your code in your payroll system to pay an employee who has a missed, late, or short meal period? And if you don't have a code for it and you're not paying employees premiums, then you're in violation, because it's impossible. Judges will often ask, 1, do you have a written policy? And 2, are you paying premiums? It's impossible, the courts have said, for an employer to have perfect employees that are always receiving breaks on time. So you should be paying premiums, and you want to make sure that shows up on the wage statement as a meal period premium or a rest break premium. Oftentimes employers will call it a penalty, which I do not recommend as the best practice, because it's a penalty to the employer but not to the employee, and employees will often argue that it's discouraging them from reporting meal period or rest break issues. In this example right here, 1 hour of pay is owed in California for in a break issue, adds up quickly. If the employee is making $15 an hour and misses 1 meal period, 1 rest break each week over just 1 year, the company and you as a supervisor under joint and several liability would be responsible for, $4,160. Multiply that by the number of employees you've had in the company over the past 4 years, and it goes crazy. And I know in the medical field, it often, my wife is actually an RN in University of California, San Diego, and she had a recent example. This stuff spreads like the coronavirus, and it's a terrible example to use, but it is a real life thing. They do have a floor right now where it's segregated from everybody else. They have to have 2 nurses present at all times with a single patient. And in that situation, they still have to make sure the nurses are getting their breaks. So they have a 3rd nurse, a resource, or a charge nurse come in to break one of the nurses at a time. So when you have people that try to make the argument that couldn't do it because of patient interaction or safety or various other issues, here's a literal situation where their nurse is dealing with coronavirus and they're being forced to take their breaks, or actually being provided their breaks is a better term, even when they're dealing with such a critical situation. When somebody else in a lesser degree says they can't take a break because they're too busy, it's something that you really need to address. Again, technically the law said, the Bricker decision is that your job is to provide breaks, not to enforce them. The reality is you do have to enforce them or police them, because if you don't have a record of the employee taking a timely meal period, you're going to have exposure. So you want to definitely implement a written meal period policy. Don't impede employees taking it. Have employees clock in and clock out for each meal period. If they don't do it, you need to counsel them and write them up. You can do it orally or in writing. Waivers are something to consider with your attorneys, and you want to talk about what is a subjective decision about what's an emergency. Again, we are dealing with coronavirus patients. They're not considering that an emergency. So unless you do have one, emergency, you want to make sure, if you do have an emergency, you want to make sure you have a waiver in place, but it can't be like a daily emergency, because then it just becomes normal practice, and that's something that needs to be remedied with staff and assistants. Here's a case in California, Augustus. We discussed it briefly about you not being allowed to take a work phone or page or anything like that. If you're taking it on your break, it's considered a violation. Some of the best practices for prevention, again, are written policies, making sure they get delivered, read, and the employee had an opportunity to ask questions and signed. Often employees will say they don't recall ever receiving an employee handbook, and the best defense you have is a signed acknowledgement form. Sometimes you get into the personnel file and there's no signed form because people just get lax. There should be the supervisor who's doing the onboarding or training doing it, and then there should be the checks and balance with a second person at least that's reviewing to make sure the file is complete. You want to do wage and hour training. This is fantastic that you're doing this now, and you want to make sure that you continue to do things like this and document that your supervisors are being trained. Use standard forms, and you got to do discipline and termination of employees. Business expense reimbursements is another hot area right now. Mileage between employees driving between clinics or such. Use of their iPhone to talk to patients or to call in sick for work, believe it or not, are all being issued, are issues for class action. Uniforms, if it's required, you have to provide it. You cannot make an employee buy specific shoes. I've seen employee handbooks where it's like you must buy this Nike downshifter shoe from this specific vendor, and it's not something that you can do in California or Nevada without reimbursement. Again, you want to make sure you're careful with your separation or termination reports. You want to document the employee is being fired or resigned and try to keep it simple. But if the employee complains that, I'm overloaded, I'm not getting my meal periods and rest breaks, then you need to make sure you're on top of that, investigate. You got to take those allegations seriously, as serious as as possible, because again, it's the biggest possible exposure for this company, for your employer, and for you personally if they report it to you and you do nothing. So you want to document everything: complaints, time adjustments, everything, and write up employees for rest break and meal period violations. Nobody does it. Nobody ever reports a missed rest break or meal period, but you guys all have employees that are having meal period issues. You need to start counseling and writing it up, because again, another one of the best defenses is to show that you have write-ups of employees, but you don't want to have an employee that has 200 write-ups for missed lunch breaks and the company hasn't done anything about it. California has various wage statement compliance issues that I have listed here. Again, I recommend downloading them and saving them to your own server and backup systems, because your payroll company is going to delete them on a rolling basis, or you're going to end up having no access to them if you switch payroll companies. There's various attorney fees and penalties and stuff such associated with wage statements. Again, you want to make sure that you have the correct name of your employer that matches up to the Secretary of State. Most of us, have online wage statements and haven't looked at it, but you need to go over your wage statement with your counsel and make sure that you have it correct. Even big name payroll companies are often wrong and are still going through the process. And at the end of the day, their contract says they're not on the hook for anything. It's all you. So look at your contracts, and it's important that you make sure you're doing the review of the information. In California, we have a new thing. So it's not new, but a hot topic for 2020 is what we call PAGA. It's the Private Attorneys General Act. And what happened was, in 2004, the state of California was out of money, and they said we can't do wage and hour compliance and enforcement. So what we're going to do is we're going to turn the regular employee into a private attorney general, and they can go after an employer for the past 1 year in the law enforcement action type of format and review all wage and hour issues for the past year. So you could have an employee that had one missed lunch break during the past year, and then they get to go after and get the names of all of your employees, their name, address, phone number. The plaintiff's attorney is going to contact them all via phone, email, ask them questions, and then that one employee can represent all the employees for any wage and hour violation. That person does not have to suffer the same violation. So you could have another employee that goes, well, I want to sue for business expense, or another employee wants to sue for overtime, or someone who wants to sue for various other things. PAGA is very complex, it's very hot, and that's because what happened was, and one of my recommendations today is that you implement, if you don't already have it, arbitration agreements with class action waivers. So arbitration agreement moves a potential claim between your employees and you as an employer into private mediation. The most important thing is it knocks out the class action portion, which ends up millions of dollars. So your multi-million-dollar case ends up being a single plaintiff case. And the only thing that you can't move into private arbitration is PAGA. So it's a very complex topic that we could talk to you at length about. But the penalties alone, I've seen recent cases settle just for under PAGA for $1 million plus. Again, sophisticated employers that are in compliance with everything, but when you look at their time and payroll records, there's issues, and 75% of any recovery goes to the state, 25% goes to the employees. So the only ones making any money on these are the attorneys. You want to get in front of it. So here's just another example, just to kind of give you an idea. In California, 12 wage and hour class actions are filed per day in the state, and 650 private PAGA complaints are filed per month. So it's only a matter of time, they say, until your company is going to get a PAGA letter or a class action notice. And if you do get one, you want to make sure someone receives the PAGA letter, you get it to counsel right away, because there is a cure opportunity for certain things that can be remedied. And I've done that with my medical clinics, and it saved them a huge amount of exposure because they reached out immediately with a PAGA letter, and we were able to cure some of the issues. For example, they had a wrong legal address on their wage statement and were using incomplete name for the employer, and we were able to remedy that under the quick time period. Just kind of going through all these various numbers. You have various cases, $65 million. There's all kinds of settlements and judgments out there. And I'm just going to go through some, as we're winding down here, just some quick prevention things you can do. You want to make sure for misclassification, your job descriptions are kept up to date and you review them annually. Audit your positions to make sure everyone's being properly paid. Manage your performance. You want to make sure not all of your employees are receiving annual reviews where they're exceptional and great employees. You want to deal with wage and hour compliance. If they're constantly late to work, put that in their performance review. Don't forget to watch how much time they spend on duties, exempt duties. Don't treat your exempt employees as non-exempt. Often employers will contact via email after hours, that type of thing. You want to train the managers. Again, train. That's, when you do sexual harassment training, this is just important, if not more important, because you do not have insurance for it and you have personal liability. So you should have wage and hour training for your trainer, your managers, or at least find a firm that does train-the-trainer programs so that you can train in-house on an economic sense. If you find someone who's misclassified, call counsel, analyze your potential liability, discuss strategy on how to resolve it. Again, arbitration agreements, misconception, you don't need one. The reality is all employers are smartly doing them right now. In California, 2020 trend, California legally banned arbitration agreements for employees as of January 1, 2020. Multiple lawsuits were filed. A federal court issued a permanent injunction right now, so you have the window where arbitration agreements are still legal in California, and it's a window that you need to have an attorney draft an arbitration agreement with class action waiver language that will pass court muster and get it signed. I would put it as number one on my to-do list right now, because without that arbitration agreement, you're facing exposure. Plaintiffs' attorneys are out there everywhere. They use Spanish radio, advertising. Here's Craigslist. Have you ever been discriminated against? Have you ever missed a lunch break? It's everywhere. The internet has opened up employees' rights and lawsuits. Please, after this webinar, just Google wage and hour settlement or verdict in California or Nevada, and you're just going to see eye-popping numbers. They're going to get single plaintiff damages could be $2,782. On a class action, it's 1.7 million. So big difference. You want to just kind of go through what to take back to the office today. Ensure accurate timekeeping, update, maintain your policies, train your employees, review records, enforce your meal period and rest break policies and discipline. 2020, the court has said you got to be using electronic timekeeping systems. It's usually one of the last things that's updated is employee handbook and your timekeeping system. Update it. Don't use a scheduling software as your time keeping record software. I've seen that happen. And then it converts to Excel and minutes are getting rounded. If you have a rounding policy, you need to review that too. Audit. Just do a self-audit. Just pick a handful of employees right now and go through. Review your practices to see there's no regular problems. I'm happy to do it with you if you want to walk through it, or your counsel or somebody, preferably someone who focuses on wage and hour litigation, because they'll know what to look for, and you can fix it. Now's the time to fix it before the lawsuit, and especially if you can get that arbitration agreement in place and signed. Make sure your supervisors don't have the authority to deny payments, adjust time, the procedures, like the email I mentioned earlier where the nurse said report 15 minutes early, and then you're not allowed to leave the premises for rest breaks. That's a violation. Again, it comes down to training of your supervisors. Keep track of your minimum wage, especially in California where your employees work. Each city is going to have pretty much its own minimum wage. If you have an employee spending more than 4 hours in, say, Los Angeles, You're going to have to adhere to their local requirements, audit your exemptions, follow up with payroll, create a team, create an organization or a few people from legal, from HR, from payroll, from management to take a look at all these issues and have a cohesive response or email chain so that everybody's on the same page and everyone knows what's going on. Keep your payroll records for at least 4 years in multiple places, even on the cloud. Review and update your policies. You got to discipline employees. You should be writing up employees for meal period violations and rest breaks if they're their fault and for failing to punch in properly. And be proactive about paying out meal period premiums or penalties. It's better to pay than have the lawsuit. So 1 hour of pay in California at the regular rate, which is another hot issue. Play offense as signed arbitration agreements, revise those arbitration agreements constantly, wash out your liability if you do have any right now, and stay up to date. Continue to go to these programs, these webinars. I highly recommend most law firms such as ours constantly do newsletters and email blasts and that type of thing. Get yourself on various lists, attend wage and hour training especially, and you're gonna do well and be well ahead. And if you do hire an HR person or anyone along those lines, or go to an insurance broker, ask them about wage and hour issues, ask them about what they know, compliance, and then find the best person that is going to protect you and the entity. And with that, I'll wrap it up again. The PowerPoint will be available to look at in more detail online. I appreciate the opportunity to speak with you today. Here's my telephone and email with any follow-up questions, and I'll turn it over to Alex.
Okay, so we do have a handful of questions. The first question, we have a mid-level provider employee who assists the surgeon in surgery. Due to the length of surgeries, rest breaks are not always available during the first 4 hours of work. Plus, occasionally there is not an opportunity to start the meal period before the 6th hour. Are we required to pay a missed rest break penalty? Are we required to pay a meal break penalty for late start lunches?
So that's a great question. One of the things you would want to do in that situation is obviously you're in surgery, you can't just break the employee. So that would be one of the unique situations where you would get a waiver if the employee worked less than 6 hours. You could have a waiver in place to say, the employee's waiving that break for that specific day. If they're doing surgeries every couple of days or so, feel free to reach out to me via email. I'm happy to discuss some options in more detail. But at the end of the day, you definitely want to err on the side of paying the employee properly. And there's some considerations to take into account too, whether or not that employee's on an alternative work week schedule. In California, it's a lengthy process to go through alternative work week schedule and very technical. Nevada, very easy. You just need an agreement between the employer and employee. So shoot me an email. I'll be happy to go over some more specifics about that situation. But in general, you can do a waiver of the meal period, but you want to make sure that you're staying on the right side of the law with regards to the waiver and when a premium payment is actually owed.
Regarding 5th hour, if an employee clocks in at 8 and out to lunch at 1 p.m., is that an issue, or should they clock out at 12:59 at the latest? How would a grace period we allow in our handbook apply, if at all? We allow 7 minutes grace period at morning clock in and 5 minutes at lunch.
Those are two great questions. So that's the first one is a great example. So the employee has to take their lunch break by the end of the 5th hour. So a lot of employers will automatically round it to the hour like that. So if it's not by the end of the 5th hour, it is a violation. So they should start it at the 59-minute mark. The best practice is to try to schedule a lunch break or a meal period earlier, so you're not running that close to the deadline. But technically, I see that happen where there's a 1-minute violation just because someone starts at 8 and then they, take a lunch break at 1, and that is a technical violation. So that's easily fixable. So that's something you definitely want to take a look at. I'm happy to discuss if you want to reach out via email or phone, some options on how you can handle that. And then the second issue was, sorry, what was the second question? Oh, grace period. Grace periods are allowed. And the good thing is you have a short period, so it's great. You want to make sure, though, when it comes to grace periods and rounding, there's basically a case out there in California, See's Candy. You want to make sure that it's neutral overall to the employee. So if the employee clocks, in 7 minutes early, and it rounds, to the nearest hour, or clocks in 7 minutes late, it rounds back, and then you're good. If it's only going one way for the employer's benefit every single time, it's a violation. If you have a policy that is facially neutral over a long time, even if it impacts one employee all the time wrongly, it's fine. But you definitely want to take a look at grace periods because there are risks for it. So you could have a fully legally compliant grace period, but the employee could still turn around and sue you for alleged class action because of it. So, and then you're on the defense and paying money. So you may want to consider, the benefits, the business benefits of having a grace period and whether it makes sense, especially in California where they want you to be paid for every single minute.
So I guess follow-up to that, is there any type of grace period at all? For example, if an employee takes a 29-minute lunch, do we still owe them a penalty?
It's another great question. There is no grace period in California. One of the issues that's different between Nevada and California is a legal theory which is called the de minimis doctrine, which is argued in Nevada saying, 1 minute is close enough. It's minimal. Basically it's Latin for it's minimal and not worth the court's time. That went to the California Supreme Court, and the Supreme Court here said there is no de minimis doctrine in wage and hour. So a 29-minute meal period, they're just literally going to look at the wage order we discussed earlier and say that is a violation. So there's multiple ways that you can deal with that. You can lengthen the lunch break to 45 minutes to make sure employees are not clocking in early. Again, it's training with employees. Counseling, if you see employees, and it happens often, you have a single employee that's constantly clocking in early, you're going to need to counsel them and tell them they got to take a full 30-minute break. But yeah, it's a technical violation, and you would owe 1 hour of premium pay.
Okay. Are employers required to ensure all non-exempt employees take their 2 10-minute breaks each day?
Great question. So the 2 10-minute breaks are rest breaks, and this is another good example going through it. If you go to a cocktail party and you ask anyone how long a rest break is supposed to be, a 30-minute rest or a lunch break, everybody's going to give you a different answer. So you're going to hear a lot of people say it's 10 minutes or 15 minutes, that type of thing. So it's an interesting thing that people don't really think about. You are correct, 10-minute breaks. They're due. You do need to provide. The law says you need to provide them. So unlike meal periods, which you have to provide by the end of the 5th hour and make sure the employee takes it, rest breaks can be movable in a sense, but you do need to provide an employee with a rest break. If they don't take it, it's their own choice. They're on the clock being paid. That's fine. Looking at it 3 years later, how do you prove that employee didn't want to take that break? So it's best, the best practice is obviously to have some kind of system or policy in place to make sure employees are notified of their right to take a break. If they don't get it in the middle, if they don't get it on time, some employers, schedule it. I do not recommend scheduling breaks, rest breaks, but you definitely need to make sure you have a policy and practice of providing them. If an employee is in surgery and misses their break, you can give it to them later because it's one of those sliding things. It doesn't have to be exactly on time. You try and make it in the middle of the day. Most people expect go to work, rest break, lunch, rest break. But yeah, the reality is your job is just to provide meal periods, and rest breaks. The reality is you're going to get sued over it if you don't have a policy of practice in place. So that's why now we're recommending that you kind of police it. So for example, in my office, I have my staff puts up a sign on their desk that says, on my lunch break, please do not interrupt, so that we all see it and know that employees are on their break, whether it's a rest break or a meal break. So again, you must provide it. Tell the employee over and over, you're not taking your rest breaks on time, document it, counsel the employee, but you want to make sure employees are taking their breaks.
Does the PTO vacation time 1-for-1 in lieu of paying overtime apply to exempt employees?
That's a great question. It's one of those depends on the factual scenario. So it definitely applies to hourly non-exempt employees. I know it's a common practice that people will do that with exempt employees. You would not be facing the same wage and hour exposure. So I'm happy to get a little bit more information. If you want to shoot me an email, I'm happy to discuss a couple more assumptions or facts on that, so I can give you more of a definitive answer.
What wage and hour considerations should I be aware of for exempt employees?
The big thing with exempt employees right now is misclassification. That's a hot 2020 trend. So it all goes back to, I use the example of the Rite Aid case. If you go to Rite Aid, which is a pharmacy, everybody's a shift supervisor. And what they did was they gave everybody a title, had them shift supervisor, and put them on salary as exempt. The reality is we know the shift supervisors are working their registers and doing all these exempt duties. So they got sued in a class action and paid a lot of money. So with regards to exempt employees, I would focus on, you don't need to worry about, the wage and hour, meal periods and rest breaks, unless they're like salespeople, that type of thing. But what you want to focus on is classification. So how do you prove somebody's exempt? Because right now, your default should be that we didn't even talk about it, everybody's an employee in California. If you have independent contractors, you need to address that to see if they're exempt or not exempt. And they're most likely employees and not independent contractors. And two, misclassification. So when you have that misclassification employees too, how do you prove to the court and everybody that employee was properly classified? So you want to have a detailed job description. You want to update it annually. Make sure you have notes from employees showing that. You don't need it for the CEO or CFO or executives, but if you have people that are lower level exempt employees, those are who I would focus on initially.
Are scrubs considered a uniform? If an employee must wear scrubs, but there's no brand or color specification, must we still pay for uniforms, or giving a stipend for them adequate? How much of a stipend?
Great question, and I've asked that question myself because my wife wears scrubs. So scrubs are not considered a uniform as long as you keep it very general and vague like you. She goes to a local shop to buy her scrubs. As long as you're not specifying that you have to wear a specific type of scrub from a specific company, you're fine. You also don't get a tax deduction for it, unfortunately, because you can wear scrubs apparently in regular life. Even though I don't know anybody that does that. It's just like attorneys. We don't get a tax deduction for our suits because we can use them outside of legal activities. So you are fine on your scrubs as long as you keep it very general and vague like you have in your description. You don't need to pay a stipend. If you do get a claim from an employee asking for reimbursement, for example, saying, hey, I want reimbursement for my employees or my scrubs, reach out to counsel or, for example, I could give you advice on it, but the general answer is no. I'm happy to work through specific issues with you with employees that try to claim it. The only way you could possibly be on the hook for it is if it's dry cleaning. So if the scrubs can't go through the regular washer because of there's body chemicals that can't get off the scrubs because of work conditions. For example, in surgery or something, you could be responsible for reimbursement for dry cleaning expenses for unusual circumstances, but not general washing. So that's the story on scrubs.
What do you recommend to track 10-minute rest periods?
So that's a great question as well. So rest periods are a double-edged sword. So we've had clients, for example, a franchisee with 5 locations that was super in compliance on everything, but they ended up getting sued in the class action lawsuit, and one of the issues was rest periods. So they actually recorded rest periods. And the problem that happens is then you end up with the same thing with meal periods. Either, the rest period is 9 minutes long or something like that. So my recommendation as a best practice is do not record rest breaks. We assume they're being taken. We want to, again, have a written policy. I would do the 2020 employee handbook. I would do email reminder if you have that capability about people taking their breaks. You would have the supervisor training about employees taking their rest breaks. And then you have a complaint procedure for employees to report if they're not getting their rest breaks. When it comes to your time clock, you're not going to record it. And then you have all these great defenses saying we've done multiple things to make sure employees have the opportunity and are provided rest breaks. And, Jane Smith had all these vehicles or tools to report any missed breaks and never did. And that's what you want to put into place now.
Since 10-minute breaks are paid and the employee missed it, how do you remedy it?
Missed it completely, then you would owe them 1 hour of premium pay at their regular hourly rate. What I do with my clients is I have a form, a standard form that includes missed time punches, and it also has, first, second, third meal period on it, first, second, third rest breaks, and then it asks whether it's voluntary or involuntary. And it has the employee explain whether or not the reason they missed their break was voluntary, they decided to work for it, or involuntary. If they check the involuntary box, then you owe them 1 hour of pay. Have a restatement of the law at the bottom, and have the employee and supervisor sign off on it. It's a great form that defeats class certification each time, because you have to look at each employee individually to see why they missed that rest break. So if you don't have a form or procedure like that, err on the side of paying the premium if it's reported to you. Otherwise, come up with a system to document it and have the employee state whether it was voluntary or involuntary and the reason why the break was missed.
In regards to mandated background and drug screening on new employees, are we required by law in the state of California to perform them?
Great question. So I tend to find my medical provider clinics and then anybody receiving federal grants and such have drug testing requirements and background checks. So technically you are not required under California law to do it. So for example, attorneys in California don't have to go through a background check and drug test. Doctors usually don't do it, but some companies or employers are required to do it. So the challenge my client's facing right now is they sent out an offer letter, did the drug testing and background check, and then had the employee, gave the employee onboarding documents, employee handbook, and various other documents, and then set a hiring date. So you want to make sure, one, that your offer letter is actually, and for any of the attorneys out there, it's a conditional offer of employment. And it's conditioned on the two things, passing the drug test and passing the background test. You want to make sure that's clear so the employee doesn't think they're hired as soon as they sign that offer letter. So that is definitely one of your top items you want to take a look at is what does your offer letter look like? I have a very detailed version that makes sure, takes away the argument that you're an employee. You're not required to do drug testing. You're not required to do background checks, but employers often will do it just to prevent them from getting sued on the other side, saying, well, we didn't do a background check on this employee and they turned out to be a serial killer or You know, they had their medical license suspended in another state. So you can do it. It's going to be an issue that's going to be heavily litigated, but I would definitely recommend reaching out to counsel to discuss specifics about it and when it's necessary and not necessary. You know, it's a touchy subject in California, and it's constantly evolving, and you know, some states are starting to prohibit it. But again, if you're receiving federal funds, you might be required under federal law or the grant to do drug testing and such. So that's part of the process you want to look at with your wage and hour team.
And that was the last question that we had for today. Thank you very much for the webinar, and thank you everyone for attending. If anyone has any additional questions, the presentation will be emailed out following the completion of the webinar, and you can reach out to the presenters.
Thank you very much, everyone, for your time. It was a pleasure speaking with you.
Have a great day, everyone.